see that the recording is going. So we'll go ahead and start at 6:04 p.m. on May 30th, 2023. We're going on the record for this hearing for file number 247-23-000124-DR. My name is Laura Westmeyer. I'm the Deschutes County Hearings Officer for this matter. And I'm going to turn things over to Mr. A.B. Johnson to describe how a little bit this hearing is going to go before we begin.
Thank you, Hearings Officer Westmeyer. Good evening. For the record, my name is Avery Johnson. I'm an assistant planner with the Deschutes County Planning Division. The item before the hearings officer is a declaratory ruling to determine whether the marijuana production facility approved under file number 247-17-1-000-908-AD has been initiated. And before I get into the hearing procedure, I just wanted to note that there will be two separate hearings conducted tonight. The applicant is the same. The properties are different, albeit adjacent to each other. So I just wanted to note that. So today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. Then the testimony portion of the hearing will begin. The applicant will present first. Next, persons in support will testify. Then those in opposition will testify. And then afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony. And then finally, staff can make any closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first name and last name as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet. I will use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, I don't believe we have any right now, but if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Westmeyer asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, and if you called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand that to me. If you are in person, please submit your written testimony to me after your testimony. If you are participating remotely, you can submit your written testimony via email to me at the email on the screen there. Hearings Officer Westmeyer and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Are there any objections to the format of the hearing? And if you are attending remotely and have an objection, please use the raised hand function. And seeing none, I will now turn things over to Hearings Officer Westmeyer.
Thank you, Mr. Johnson. We're going to be following normal hearing procedures in the county code. Mr. Johnson, how many people do we have who are looking to provide testimony tonight? Do you know?
The applicant and his legal representation are in the room. And those are the only people attending currently.
Only the applicant. Okay, thank you. I'm just going to go over the rest of the procedural steps. Thank you for your patience in that as we get through this. So this is, like Mr. Johnson said, a declaratory ruling request. This application is being considered through a quasi-judicial process. I'm only going to be able to consider the factual evidence that is in the record by the end of the close of the record. I'm then going to apply the law and the relevant provisions and applicable provisions of the county's comprehensive plan and land use regulations to those facts as they're presented. The standards and applicable criteria that are relevant to this hearing and the application were identified in the public notice announcing the hearing, and they are set forth in the staff report, which is part of the record in the case file available online and posted to the county's website. They are also available directly from staff upon request. For anybody who's going to be testifying, the applicant and the applicant's representative, please direct all your testimony to the standards and the applicable criteria. If you believe that a criterion was not listed, but that it does apply to this application, please point that out and explain why you believe it applies. If you have any criterion that you believe do not apply, please do the same. Let me know why you believe it does not apply and explain that. Failure to raise an issue with enough detail to allow me or other participants to respond will preclude your ability to appeal that issue in any later appeal to the Land Use Board of Appeals. It may also preclude an action in damages in circuit court for the failure to raise any constitutional or other issue relating to any proposed condition of approval with enough detail to allow me to respond to the issue in my hearings officer decision. As I noted, I am the county's hearings officer for this matter. My role is as a neutral third party decision maker. With that, I have no ex parte. I've had no ex parte contacts concerning the facts or issues in this hearing, and I do not represent the county's interests or the interests of any other participant. I have no bias or prejudice to report. Does anyone wish to challenge my ability to conduct the hearing?
None in the room. Hearings Officer Westmeyer.
Okay, thank you. So I'm going to go ahead and turn it back over to Mr. Johnson to deliver the staff report, and we'll get started that way. Mr. Johnson.
Thank you, Hearings Officer Westmeyer. I'll now present the staff report for the 124 DR application. The subject property is located at 26285 Willard Road in Bend, Oregon, 97701. It is approximately 25 acres in size and is developed with a residence and a few accessory structures, including the 2 agricultural buildings for which costs were claimed as part of the initiation of use for marijuana production facilities. The request is for a declaratory ruling to determine if the marijuana production facility approved under file number 247-17-000-908-AD has been initiated. Staff notes the original approval for the marijuana production facility included a proposal for 3 4,200 square foot greenhouses and a 320 square foot storage container, none of which appear to have been constructed. The 2 agricultural buildings for which costs were claimed as part of the declaratory ruling application are for and in conjunction with farm use and agricultural activities per a statement of intended use signed by the property owner and a plan or comment on the building permits for the agricultural buildings. Per the site plan, you can see that there are 3 proposed greenhouses and a storage container to be used for marijuana production. The site plan also shows 2 future proposed buildings. The 3 greenhouses do not appear to have been constructed, but the 2 agricultural buildings have been constructed. Staff notes that only the greenhouses and storage container were approved for marijuana production. The land use decision does not recognize or otherwise approve these 2 future structures for marijuana production. The structures for which costs were claimed appear to be located in the area where the 2 quote-unquote future structures are illustrated on the site plan. Staff includes the initiation of use code section on this slide. And per Deschutes County Code, initiation of use has been met when 1, the proposed use has lawfully occurred, 2, substantial construction toward completion of the land use approval has taken place, or 3, where construction is not required by the approval the conditions of a permit or approval have been substantially exercised, and any failure to fully comply with the conditions is not the fault of the applicant. Staff also includes the substantial construction definition as defined in Deschutes County Code, which reads, substantial construction has occurred when the holder of a land use approval has physically altered the land or structure or changed the use thereof, and such alteration or change is directed toward the completion and is sufficient in terms of time, labor, or money spent to demonstrate a good faith effort to complete the development. With the relevant code section and definition in mind, staff identified the key issue areas in this matter are that costs were incurred prior to land use approval. Did the owner demonstrate a good faith effort because of that? And the 2 agricultural buildings for which costs were claimed were not approved for marijuana production. In this case, it's clear that construction had taken place prior to when the property owner was the holder of a land use approval. Therefore, it's unclear if these expenditures meet the definition of substantial construction as defined in Deschutes County Code, and consequently meet the relevant criteria to claim initiation of use under Deschutes County Code 22.36.020. Additionally, it's unclear to staff if the cost claimed for the 2 agricultural buildings should be considered as part of the initiation of use analysis, as these buildings didn't receive land use approval from the county for marijuana production. And with that, staff is now available for any questions.
I have no questions at this time, Mr. Johnson.
Thank you.
Okay, we'll now take anyone who wishes to speak in favor of the application.
This is just on 26285.
Correct.
My name is John Watson. I'm the landowner, or building owner. Address is 26295 Willard Road, Bend, Oregon, 97701. Little background on myself. I grew up in Oregon, in Klamath Falls. I initiated this, purchasing this property in 2015, both properties, 2015 and 16, for the use to eventually use them as marijuana grows. I spent several years in the military before owning my own businesses, and I've been traveling quite extensively, and in my spare time developing these properties. On 26285 Willard Road, this was the second property that we had purchased as it became available next to the original piece of property at my mailing address at 26295 Willard Road. We initiated this because we found that this would give us a larger production area based on the code. And so we started construction on the buildings, the future buildings, and we did not put the greenhouses up on this property at that time because we have not started actually growing, and we didn't want those to be damaged. And we also needed the future buildings for electrical use, so that we could have electrical run out to the property, because we would need those at the greenhouses as well for the odor and noise control.
When did you first start talking to the county?
We started this process in 2017 with the county. We had purchased this property because it is an exclusive farm unit, EFU. We did not see that there would be an issue with getting a land use approval. because it was farmland, and this being marijuana was being considered a crop, so that's where we started. We started construction because of on the buildings, because we knew we needed to get the power, we needed electrical power out there, as well as this was going to be what we considered the final product. We did have these buildings as part of our initial applications, but we did take them off only because we didn't know when the construction would start, if it was going to start. We ended up starting it while the application was already in the system with the county, and by the time that the land use had been finally approved, we had already had these buildings built. As part of what I do, I have no other investors in either one of these properties, so I was spending my money as I was earning the money. And so by the time the land use was approved, we were, I had spent quite a bit of money on this, and so I didn't feel that we had already spent, about 80% of my budget on this, and I didn't feel at the time, or before the market became less, less marketable, where my return on investment wouldn't be there. We decided we just hadn't bought the actual greenhouses yet, but we had put these buildings up. So, but this is easily 80% of our budget for doing this. The greenhouses are kind of an afterthought. They're just because they're so small. They're just a small part of the cost themselves, considering what we've done so far. Something else I should bring up. As part of this as well, since the 2017, I've had at least one full-time employee on the site developing this property. That employee is still with me. I had 2 employees full-time out there until 2019. And then we had started also in 2018. We had changed over a temporary to move permanent irrigation rights from 26295 Willard Road, and we'd had the portion of those irrigation rights put onto 26285 Willard Road, so that we would have the water use for the production of facility. Let's see what else. The intended use from the beginning has always been for marijuana production at some point. Again, the majority of this has, before and after before April of 2022, even in 2018, these buildings were there. They've been there. I've spent the money on them. It's again, 80% of the budget has been spent out there getting these ready for production. If it wasn't for a kind of a crash in the market and then COVID happening, I believe we would have probably would have started the actual grows before this point. But instead, we've just kind of pumped the brakes to see what the market was going to be like, and then in September of 2021, my attention was taken away from this property and monies that were being spent on it Although I still have a full-time employee out there, my mother, she has Alzheimer's, and on 26295 Willard Road, I moved my parents to that property, which that has taken up most of my time from that point forward. So, but either way, I thought that we were supposed to. I thought we were supposed to have all of this built before we could get an OLCC license. That's where I was, and also because of budget constraints each year. But in the end, I've spent very little money to this point since April 2022, other than some security and cameras. Everything else was done prior to 2022. Most of, like I said, 80% of this was finished in 2018. This, we purchased the land as only being a marijuana production facility. I wouldn't have purchased it otherwise, and I've made significant changes to the land based on what was sent back to us in these findings. I think we've shown that we've definitely altered the land and made changes. And all this money that's been spent has been towards trying to complete the development and get this ready for licensing with OLCC, which we're working with now. Anything else I should bring up? I think that's everything that I could possibly cover at the moment.
Thank you, Mr. Watson.
I'm sorry, I didn't know that I was on the camera, and so I was looking down the whole time. I'm sorry about that. I could
Not a
have been
problem.
looking at you. I'm sorry.
Anything further from the applicant?
Hearings Officer Westmeyer, would you rather have me give a public statement, or would you rather have me just give some summary remarks towards as a lawyer, not as a public statement?
Well, I think either way now would be the time
Okay. Very good.
to present.
Yeah, I don't think we have anybody else, so. All right, thank you.
Yeah, I will say in particular, you heard Mr. Johnson mention that in the original land use approval, the 2 agricultural buildings were not approved as part of that approval. So I'd like to hear you speak directly on that if possible.
Yeah, if I could, originally, Mr. Watson and myself met with the county, I would say in spring or early summer of 2017, and there were several different proposals that were submitted before the final proposal was submitted. Early on, the buildings were part of the original proposal, but then the buildings were presented as a future development. When a lot of these people were starting these businesses, especially back in 2017, they were doing so with the eye of expanding, and especially in this particular case of potentially adding another license to the production license. And back then, there was no moratorium in place by the state licensing. The county was still allowing people to get licenses. So when people were talking to the county, they were looking at, hey, here's what we want to do. County says, here's some restrictions based on the size of your lot. You have certain lot restrictions, for indoor and outdoor. And so then the people who are applying for the licenses kind of have to decide, well, I'll start small with the greenhouses that are smaller, and then eventually move to something that's bigger. Now, in this particular case, the land use approval was for indoor marijuana use, and as part of the overall plan on that plot was to add the 3 greenhouses. But as Mr. Watson explained, to get infrastructure into that property, because that was kind of a property that didn't have a lot of infrastructure on it, they built these agricultural buildings for the purpose of having some of that infrastructure for the electricity inside of a building, right? I think it's the the panel, there we go, that's the word I'm looking for, the panel, the electrical panel and other things that they need to actually run the electricity. So these items would have had to been built as part of the infrastructure to be able to complete the land use application. And the greenhouses are actually a very small portion of the cost. The greenhouse frames are very, I think when we get to the other property, you'll see what a greenhouse frame costs, and it's much less significant than the costs of these two agricultural buildings. However, these two agricultural buildings, even though they weren't specifically approved for marijuana use, and that particular application was looking at the greenhouses, the county approved indoor growing, and so therefore all Mr. Watson would have had to do at some point prior to the county opting out would have been to submit a separate land use application for that use, but he would not have been able to do that had he not been able to go in and put the infrastructure in place. So I think when you look at the two agricultural buildings, and there was a comment made about them being the permits issued as agricultural or for farm use, and farm use and marijuana under the statute is the same. Under the statute, marijuana production is considered farm use. So most people, when they apply for building permits, there hasn't been a specific marijuana use under the state statute. There had been previous farm use. So often you will see people use farm use as a synonym for marijuana production. And the county was aware when he filed for all these permits, and especially the electrical permits and some of the other things that you see on the costs that have been submitted for that, for the HVAC, the electrical, a lot of those construction costs and some of the equipment that was purchased would have been used in the actual production operation. For example, for Mr. Watson to actually start producing marijuana in the greenhouses, he would have had to had fans and electricity to operate those fans and some of the HVAC equipment that was recommended to him by the noise and odor engineers. And so these are all components that would eventually have to go into the greenhouse, so were purchased for the purpose of when the greenhouses are up, these components can then go into it. And so a lot of these costs are associated with the costs that were required by the county to actually operate the greenhouses, and often those costs are more expensive than the greenhouse frames themselves. As we mentioned, the greenhouse frames themselves are a very tiny portion of the costs compared to the equipment that goes in them, the electricity to actually operate them, and some of the other costs that have been listed for 26285. And I believe when you look at all that, and I understand what the county's saying, and it appears to me that the issue is that Mr. Watson completed a lot of these costs, and a lot of these costs were incurred before the finalization of the land use application itself. And Deschutes County took a unique position when it come to land use applications for marijuana use in the EFU production. Most counties didn't require these extensive land use applications for EFU. Deschutes County did, so therefore the process took a lot longer. And so Mr. Watson starts working with the county in, let's say, May or June of 2017, get a good idea what they're doing, starts the process, starts clearing the land, starts clearing the area, starts building the buildings for the electricity. The area where the greenhouses has now been cleared, and now they can actually just drop those in because they've done the site prep for those. This was all done prior to the land use approval, and that is the issue that seems to be that the county's asking to kind of get resolved here is whether or not somebody can complete the land use requirements prior to the land use approval being granted. And when we look at DCC 22.36.020 subsection 2, that's the section I believe is appropriate, and I believe the staff's report helps narrow that down to that subsection. And that's the section that requires substantial construction towards completion of the land use approval has taken place. And then they further talk about how substantial construction is physically altering the land or the structure, or changing the use thereof. Now, in this case, it's obviously physically altering the land and the structure. And so what we see here is you got two requirements, right? You have to have the alteration of the change, and that has to be direct towards the completion of the project. And it has to be sufficient in terms of time, labor, money to demonstrate a good faith effort to complete. And so I think when we look at this analysis, we can see that all the work that Mr. Watson has done on 26285 prior to April of 2022, every bit of that work was done towards this project. Every bit of it. And the fact that these two buildings weren't at that time part of that approval doesn't mean that they aren't integral parts of the project itself as far as having electrical infrastructure. And it's also part and parcel of when they clear that land and prep that site, that the area to the west of those, if you look on the plot plan, is where the greenhouses would be located, and all that work was done at the same time. So when you go and Mr. Watson can explain this more, but when people do construction, if they know an area is gonna be developed a certain way, they want to prep that whole area for that future development, not just one portion of it and then come back and have to site prep something next to it. So the whole area was site prepped. The only thing that hasn't happened on that property is the purchase of the greenhouses. And again, that would be such a small portion of the budget that when you look at that, you would find that there was substantial construction that physically altered the land or structure, and the only purpose of that was for this project. And you have to, the land use approval is part of a bigger project. And yes, the land use approval is for indoor marijuana use, but the larger project involves all these costs that were associated with it, including permits and everything else, because you just, again, when he's doing a project, he's prepping the whole site, not just a little portion. So when he's pulling permits, those electrical permits have to be pulled and have to be placed at the property so that they could be attached to the greenhouse. Greenhouse usually doesn't have its own power source. They have to come in off another panel, and it's often multiple panels depending on how much equipment is in the greenhouse. So sometimes there is a significant electrical outage used in the greenhouses, and that's why they have to have that infrastructure in place. So then I think when you go through the initiation analysis for 26285, you ask, do the expenditures result in alterations and changes? I think that is a yes, without question. Are the expenditures directed towards the completion of the development? I think, once again, 100%, all the expenditures are directed towards the development. Portions of it are for the greenhouse, portions of it for the site prep, portions of it for the buildings. But I think he said 80% of their budget has already been spent there. And I think the other 10% is probably security, and then a little bit on the greenhouses. So in this particular property, the expenditures were significant and they were directed towards the completion of the development. And then finally, do the expenditures demonstrate a good faith effort to complete the development? And this is where the question of, he finished a lot of this before the land use approval. And I guess from my perspective, that shows somebody who's on the ball, getting stuff done, had met with the county, has an idea what they're doing, knows what they've got to do, goes to the county, gets all these permits. They're not doing anything, where they're not getting permits. It looks like they're doing everything they're supposed to do. And it appears to me this would be considered a good faith effort. Now, I did try to scour the LUBA cases and the Court of Appeals and the Supreme Court cases for this kind of issue, because as the staff report indicates, it's unique, right? Can you initiate the use before the actual approval occurs? I think the obvious answer is yes, you can. And that's when you just read the plain language of the code, it would appear that, right? It says substantial construction towards the completion of the land use approval has taken place. It doesn't say after the approval. There's no language in there that says it has to be after the approval. And so I think the plain reading of the code would indicate that. But then if we look at the Gold v. Deschutes County I'm trying to think of the Thornburg, the Thornburg case that Deschutes County's been litigating now for a decade or so. I was able to go through some of the LUBA issues that they discussed in that case, because it applies to Deschutes County. It's applying the same code. And it was interesting in that case, if you go down to page like 23 and 24, the petitioner raised an issue in that case that said that some of these things were completed before. I think in that case, the court changed the dates for the two-year initiation based on some stuff, so they bumped the dates up. And then the petitioner argued, well, some of the things that the hearings officer claimed were completed were actually completed before that new date, right? So they were completed before the new date came up. And then, so the petitioner was saying, well, you can't do that. It happens before it was actually, the condition was approved. And so if you look on page 24 of that LUBA decision involving Gold v. Deschutes County, it's LUBA number 2012 at 42. That's 2012-042. And on page 23 and 24, they discuss this predate issue and where the petitioner raised that. And LUBA rejected that argument by the petitioner. On page 24, they basically said, even though DCC, and they're citing section 22.36.010, they're saying even though that doesn't anticipate a condition of approval satisfied before it's imposed, where that is the case, it would not have intended, in other words, the drafters of the code would not have intended to require that those actions be duplicated after the conditions is imposed. They essentially said that was an absurd argument, saying that, okay, even if it was done before it was approved, you wouldn't then make them go and redo that. In other words, that condition had already been met, even though it had been met prior to the new date that was set as the time for the two-year initiation period. So even though I don't think that case directly addresses this particular issue, I do believe it does show that there is a tolerance in the land use, and especially in Deschutes County's code, for somebody to complete a condition prior to it actually being imposed. So I would ask the hearings officer to look at that. And also, I just as a side note, and on that, I don't believe that completing the greenhouses was necessarily part of the approval. It had been necessary to actually get the license, at least at the time it would have been. Now it's actually not necessary. But just in reference, I do believe that this applicant has met the analysis of whether or not the use has been initiated. I do believe there was substantial construction. I do believe that led to changes to the property, and those were 100% related to the completion of the development. Even if you, for argument's sake, take out the construction of the two buildings, there's still a significant amount of costs that were placed for this project that were directly related to the greenhouses themselves. So in my estimation, I believe this should be a fairly easy analysis in that Mr. Watson did expend a considerable amount of money towards this project, and that demonstrates a good faith effort on his part to complete the development. And that's all I have.
Thank you, Mr. Hughes. What are the timelines? Is the county and the applicant on the same page in terms of what, can you point me to in the record, what's the timeline for the original approval, and were there any extensions? That would be a...
Yeah, and just for the record, the approval, or the record should consist of our application, I believe.
Mm-hmm. Yes, I
And
have
I'm just
that.
trying to see if our application actually, yeah, here it is. Okay, so property was previously approved April 12th of 2018, extension in 2020, and another extension in 2021.
Okay, so the extension in 2021, what date did that extend the approval to?
To April of 2022. And I don't have the exact date in April.
Okay, thank you, that's fine. Just a quick question for Mr. Johnson. Is the original approval part of the record? I don't see it online. Am I just missing it? The 2017 AR approval?
Yeah, I mean, that is part of the record. And
See, there are excerpts in your staff report, but is the actual approval also in the case file somewhere?
I'd have to double check on that, but I believe it is. If not, I can certainly upload that to the record.
Okay, please do. Thank you. Okay, Mr. Hughes, just one more question for you, and actually it's, apologize, it's the same question. I understand your argument, and I appreciate your pointing me to the LUBA cases, and I do understand this will be an interpretation, so it's good to know your position on the predate construction. My question is just, and again, I think it's, I haven't seen the initial approval. But in terms of those two agricultural buildings, what I heard you saying, and Mr. Watson, and through Mr. Watson's testimony, is that those buildings are essential to the indoor marijuana production facility, which what the original approval was for. So why weren't they included as part of that approval? Was it because they wouldn't have met that application?
So when we initially had started this, there was, of course, the thought, the excitement, the feeling that we could get started quickly with production. That turned into something that was not true, because there was these other things that needed to be put in place before the county would approve it. And, some of those, we just going out there, we didn't want to. One, first thing was I was thinking about budget, and how am I going to pay for this? So the initial thought was, okay, we'll just grow in the greenhouses themselves. We'll get licensed, we'll get the land use, we'll get licensed by OLCC. That will start paying for what this budget, what the overall budget is going to require. But once I went through the counties, once we went through the county's requirements, I had hired an engineer. And, after speaking with Mr. Hughes and getting his advice, is that we needed to, there was things that we had to have at those greenhouses that I wasn't going to be able to provide. And the biggest thing was the odor control, the noise engineering, everything that goes with that, and can't do that without power. And at that time, because I was thinking money-wise, I was thinking, what am I going to do this? So instead of, so when I was going to purchase this property itself, I had to think of that when I was going to the bank. What am I going to go to the bank and get from them? And part of that was the budget to build the future buildings that would incorporate all the power, all the necessary items that we needed for the greenhouses themselves to start production. Well, so it ended up turning into a flip-flop of what we actually wanted to do. I wanted to initially just go and start growing. And what I found is that I was running into requirements that I didn't feel like. There's a grow across the street that has 50 different greenhouses out there, but I was being told I could only put 3 on this property, and my property's bigger than theirs. And so I was running into all these things that were back and forth, being told one thing by the county, this is what all you're able to do, and you have to meet these requirements to get this land use. But then I wasn't seeing it on the other side. So I was thinking in all these different terms of what the budget is, where am I going to get the money from to, develop this property, because I'm the sole investor. I'm the one that signed for it. I'm the one that bought the property. So when I bought the property, I had to have real buildings in there in order to get the loan to be able to put all of these items in. To be able to get HVAC out there, power out there, I had to have physical buildings for the bank to look at. They were not going to accept, greenhouses as a permanent building. And so I had to go and then spend that money with the bank in order, and put these buildings up. And my thought this whole time was we were going to, once we were licensed, we would have those greenhouses up, we'd have all the infrastructure in for them. So instead of, the initial thought of, okay, we can go out here and, it's kind of like the Oregon Gold Rush, and Oregon Green Rush, I guess. We can start immediately making money, and that's going to cover some of the costs of this. And instead, it turned into, I had to meet all these different requirements that we were unaware of when I started this. And so in order to purchase property, get these requirements met, I had to build these buildings. And since that point, I mean, all the buildings have been built, everything's been out there since 2018. I've spent very little money on the buildings and the infrastructure, because the infrastructure's there, it's in. All I have to do now is just buy the greenhouses and put them up. Those are one-day operations, and I've already seen that because I've done that on the other property. We have a greenhouse up there, we have the frame up there, where it's ready to go except for putting the skin on it, and we have the infrastructure in place. So it was some of it was a learning curve on my side. Some of it was, there was a lot of different things happening back then in 2017 and 18, talking with the county. They were still developing all their requirements of what they wanted, what they were doing, and a lot of these things have changed since then. But that was the initial thought, is that, and why that was part of the initial application, only putting those as future buildings and putting the greenhouses, because I thought we were going to be able to start growing, and even just having an outdoor grow. But it seemed like every time that we wanted to start going and get the paperwork going and get everything approved, there was some other roadblock thrown up in the way. And the biggest part being, we'd have to have power out there, we'd have to have infrastructure out there, and the only way to buy the property and get the infrastructure out there was to actually put up some buildings that the bank could say were worth the monies that were going to be spent. And in the end, I still have the money sitting there waiting to buy these greenhouses, but the infrastructure, everything is there and in place. So that's, to me, that's exactly why we've done what we've done, and because in the end, the greenhouse, I understand that they're saying that those are what were approved. Those are the simplest thing to put up. I had to, in order to get all that started, to even put those up, I have to have all these other things up. I couldn't buy the property and build the buildings and get the infrastructure there without, that's where the investment came. That's where it came from. I got a loan from the bank to do that. I don't have outside investors. I don't have somebody else out there that's, some kind of angel investor out there that's giving me money to just, get everything up all at one time. So that's why we did what we did and how we did it at the time.
Thank you. Anything further from the applicant?
I don't believe so.
Okay. I don't believe there are any, but is there anybody online or in the hearings room who wishes to testify in opposition to the application?
No one in the room and no one online.
Okay, anyone for neutral testimony?
No.
Okay, there's no need for a rebuttal, unless you'd like to offer anything additional.
Not for us.
No, I don't, thank you.
Okay, then I will just note, I see no reason to keep the record open unless somebody wants to make that request. Already as part of the record, I will note are the original land use approval decision and the extension decisions should be a part of the record. If Mr. Johnson, you can just make sure those are online on the county's website so I can access them. I'm not sure if I don't see them now, but if you could make sure they're on there, that would be great.
Yeah, absolutely. I'll upload those as soon as I can.
Okay. In that case, we will close the record and adjourn this hearing. Thank you all for your time.
He had, he's deceased now, but he had arms like fucking pop up. That was full.
Hi, Hearings Officer Westmeyer.
That's
Can you hear me all right?
I completely apologize. I know we had talked about doing a consolidated hearing and we separated them into two, and I completely left not remembering that. So is everyone still in the hearings room?
Yeah, everyone's still here.
Okay, I think we can do sort of a consolidated introduction in that case, since the applicant is the same,
Sure.
represented by the same Mr. Hughes, I presume.
Yes.
Yeah.
But we will go on the record. I see the recordings going, and this now is for the hearing for file number 247-23-000125-DR. Is it 125 or 124?
125.
125, right. Okay, thank you. My name is Laura Westmeyer. I'm the hearings officer for this matter. I have no Mr. Johnson, did you want to go ahead and go over the procedure, or I'm happy to skip that portion?
Yeah, here's Officer Westmeyer. It's ultimately up to you if you want to skip the Zoom instructions and procedures and just move on to, I can just go into my staff report if you want.
Yep, I'll just say for the record first, I have no bias prejudice to report. I have no ex parte context concerning this land either. Same as the last hearing. And does anybody wish to object to my ability to conduct the hearing?
Not from the applicant.
Okay, thank you. And hearing none from the county, please go ahead and go into the staff report. Thank you.
Thank you, Hearings Officer Westmeyer. So the subject property for the 125-DR application is located at 26295 Willard Road, Bend, Oregon 97701. This one is approximately 10 acres in size and is developed with 2 lawfully established dwellings, a stick-built home and a manufactured home, and as well as several accessory structures. The request is for a declaratory ruling to determine if the marijuana production facility approved under file number 247-17-000907-AD has been initiated. Staff includes the approved site plan under that referenced file number, and per the site plan, you can see that there is 1 proposed greenhouse and 1 proposed storage container to be used for marijuana production. Based on evidence in the record, the greenhouse does not appear to have been fully constructed, and per the applicant's incomplete letter response, the greenhouse frame was erected sometime in 2017, and associated equipment was purchased around that same time, which again was before the land use approval was final in 2018. However, the applicant relayed in the incomplete letter response that the majority of equipment listed in the invoice has been installed, and much of that after the land use decision was approved. Staff again includes the initiation of use code section on this slide. For time's sake, I'll go ahead and skip over the code section here. And then we also included substantial construction definition. And again, for time's sake, I'll skip over that as well since it was already introduced. So the key issue areas in this matter are initiation of use, substantial construction, and good faith effort. In this case, it's clear that construction and associated purchases had taken place prior to when the property owner was the holder of a land use approval. As detailed in the staff report, many costs claimed were prior to the property receiving land use approval. Therefore, it's unclear if these expenditures meet the definition of substantial construction as defined in Deschutes County Code and consequently meet the relevant criteria to claim initiation of use under DCC 22.36.020. And with that, staff is now available for questions from the hearings officer.
I don't think I have any questions at this time.
Okay.
Thank you. So we'll go ahead and take testimony in favor of the application.
Okay. Thank you for coming back. I was in England yesterday, today I'm here, and tomorrow I'm in Texas, so it would have been very difficult to come back again on quick notice. So thank you for coming back. On this property, my name is John Watson. The mailing address 26295 Willard Road, Bend, Oregon 97701. That's the property we're talking about now. This was the first property that I purchased. Again, purchased property, and this one, I only received a loan for the actual property itself, not for the development of the property. So in 2017, once we had initiated contact with the county, and I had also started hiring the engineers, also Mr. Hughes as advisor, as a legal advisor. I truly believed, and I do not fault the county for this. I know back then there was a lot of things that were happening, that were changing along the way. So I believed in good faith that we were going to receive the land use approval, and so I started purchasing the equipment and everything that I would need for this. Again, same thing happened on this property as the other property. We believe that, providing the greenhouse, getting the greenhouse, we were going to be able to start production in a quick manner, just because, marijuana can be grown outdoors. What we found is there were several roadblocks, again, things that were going to be required by the county to get the land use. And so this changed the direction of how we proceeded. This property already had a structure on it that I was able to use as the infrastructure. One item that we did not list here, that I failed to list, that I see now as I'm looking at this from this list on the analysis, is we had to upgrade the electrical in the building that the greenhouse is sitting next to. So there was another approximately $38,000 that were spent to upgrade the electrical to an 800 amp service, so that we would have capability to run the equipment that we were purchasing here, and also for the odor and noise engineering equipment. So that again was initially the thought was this one would be a facility that we were able to get in, we thought we'd be able to get into production in a quicker manner so that it started producing revenue that I could use to continue developing the land. So this, the amounts that are shown here, less the approximately 38,000 we spent on upgrading the electrical. That was monies that were taken directly from me personally, no other investors, to start production as quickly as possible. What we found after the land use is that after we received the land use, of course, at that time, the market went downhill, so there was no need for me to start producing at that time, and I also wanted to continue developing the property, and I needed to, and so instead of trying to raise revenue through the production, I've just spent money since then up to and beyond April of 2022 to get this ready for OLCC licensing. The numbers that are shown here in this analysis are, 100% of what I say 100%, it's 90 to 95% of what we needed for this development. There's been very little that's been spent after 2022 on this property. Same thing with this property. We also have labor expenditure where we have full-time employee there that's been there since 2016. And is still there to this day as part of this, who's taking care of the property, the irrigation, things like that go into what the facility will need as a production facility once we start growing.
What do you have left to complete?
As far as completion of this, we just everything at this point is complete. After 2022, the only thing that we had left was security that was required by OLCC. That's the only thing that's been updated since 2017. That's the only thing that has been done in the facility is upgrade after 2022 was the security systems, I should say. So we're requiring cameras, steel doors, things like that. Those were upgraded around the 2022 time frame. Anything else I should be talking about?
Did this change the property?
Oh, yes. Talking about alteration or changing of the property, one is the electrical upgrade to the property. We cleared land for the greenhouses. We've changed, we have changed the water rights so that they're at the buildings themselves in the greenhouse, so that we have water use. Let's see what else. And of course, this property again was purchased at the time, and this development, these items purchased and upgrades made for the sole purpose of marijuana production. We have not tried to produce anything else. We haven't tried to. We don't have animals on the property, nothing else like that. Same as the adjacent property that we've talked about previously. This is all sole purpose has been for marijuana production.
Anything else you think of?
I'm thinking, I don't think so. Yeah, I think that's all I have.
Thank you, Mr. Watson. Anything further from the applicant, Mr. Hughes? Anything?
Yeah, it appears that it's the same issue here, Your Honor, your hearings officer. When we look at the amount spent, including the $38,000 that he just testified was towards the electrical upgrade, that is it sounds to me like the only thing they've got to do there is put a plastic cover on the greenhouse. The frame's there, all the equipment for it's there, and all those expenditures are 100%. He discussed how it's changed the property, the addition of the greenhouse, the upgrading the electric, but these expenditures are all towards the completion of the development, and it is a good faith effort by Mr. Watson to do this. It comes down to, again, the issue of, can this occur before the actual land use approval occurs? And again, I refer back to the code, which just specifically says, whether there's been substantial construction towards completion of the land use approval has taken place. It doesn't say whether or not that completion has to occur before or after the land use approval. So again, the code is silent on that. And then I would refer Hearing Officer Westmeyer to the LUBA number 2012-042 decision, one of the Thornburg decisions where they talked about how it would be absurd to require people to redo a condition that they had actually met prior to the approval. So I think that case gives us some insight onto how we should interpret this. I would also note that part of the problem that LUBA had in that case was the hearings officer interpretation of the code required what LUBA considered to be basically adding language to the code, and that's why I mentioned that the code is silent on this issue. But LUBA doesn't seem to be. I believe if you read that case, you'll see that I think it's contemplated by LUBA and by the code that people could actually complete the requirements of the land use approval prior to the approval. And I believe in this case, that is exactly what happened. Mr. Watson expended all this money on this particular property. I think he said 95% of his budget has been spent. That was prior to the April 2022 time period. And I believe because of that, he has shown that he has initiated the use by completing substantial construction that altered the property, and he did so in a good faith effort to satisfy the requirements of the land use development and approval that he had obtained. And that's all I have.
Okay, thank you, Mr. Hughes. Just a clarification on the greenhouse. So, let's see, the county, Mr. Johnson just said there's no greenhouse on this property. Mr. Watson said the land was cleared for the greenhouse and the invoice shows a greenhouse was purchased.
Yep.
So, and I think you just said the frame was on the land. So can you just clarify what?
Yes, the frame and everything has been built.
On this
Yes,
property.
again,
Okay.
we weren't producing, so we didn't put the skin on the greenhouse. So, but it's all still there. But the greenhouse it is sitting there on the land that we cleared, and the framing is all up and ready for production.
I think he just needs to add plastic and the greenhouse would be ready to go. So I think he's got one small expenditure of plastic, which would be minor compared to.
Yeah, we have it.
Oh, yeah,
Yeah, that's
they
part
actually
of it.
have, they actually purchased the plastic, it sounds like. They just have to put the plastic
we,
on it.
We purchased it as a whole product, and again, we were thinking this was the first property purchase, so it was almost, at the time, the thinking was that this was gonna be our guinea pig to figure out how to grow, when to grow, like what all the process was gonna be, because I honestly have never grown marijuana before, and so I was taking cues from people that had, and this was, since this was the first property that was brought, that I purchased, that was the thinking. And we did have a medical grow there, where we worked out some of the, some of the kinks in the system about how we were gonna do things, what we were gonna do, because portion of this equipment is hydroponic, and we needed to make sure we understood how it all worked before we purchased more equipment for the other property. So that's why there was already, we had a greenhouse, and at the time, I didn't think that we would be doing both land use applications at the same time or having them approved at the same time. And so we thought that this one was going to happen faster, and it did not. So that's why the greenhouse was put on the property. And also, I did not have to wait for the infrastructure other than the upgrade to electricity because the building was already on the property when I purchased it, the building that has the infrastructure in it now. That building was already up, so I didn't have to wait to construct it. Just had to get the upgrade in electricity, which happened rather quickly. So that's why there's a greenhouse on this piece of property and ready for production. But again, the market downturn pretty much precluded me from starting production or even pursuing the OLCC license at that moment. Because we weren't sure what the market was going to do, and I didn't want to keep spending money on something that we weren't sure what was going to happen with it. So, but this was money spent out of my pocket here.
And that was in 2017, right?
Yes, in 2017, yeah. And again, that, I still to this, even to this day, I think that, that the county has been forthright with what they've said to me about things, and I've trusted what they've said. And even back then, that's why I started, is because I didn't feel that they were, leading me on or leading me down the wrong path. And I don't think they are now. I think they're following what they have to follow now. But that's why I started the construction on both pieces of property the way we did, because I had faith that they were going to approve the land use. Because there was really, I couldn't see any reason, I couldn't, after talking with the county, they were giving no reasons why it wouldn't be approved. So I started spending the money and getting this done, because I thought that we were going to start production, and that was the revenue from some of that production would cover some of my costs. And again, we just started running into more roadblocks with what was being required and things that were changing at the time, and apparently are still changing to this day, with different legislation and different things, codes going with the county, what they're looking for. And so we didn't start production, but we did have everything ready back then. And again, I think the biggest thing that happened and slowed me down was, one, I spent the money, and two, I didn't see a return on investment because the market had such a downturn after 2018. I didn't see that it was going to be worth trying to start something, and so that's why we got to the point where we are now, is because I was waiting to spend more money on something until it was the right time. So, anything else I should be talking about? I don't think I have anything else on that.
Okay, thank you. Is there anyone who's appearing to testify against the application in opposition or neutral?
No one in the room, and it appears no one online either.
Okay. I assume no rebuttal is necessary. So again, here, I'll take the matter under advisement. Is there anything further from the applicant?
Nothing from us, hearings officer.
Okay.
Hearings,
Okay, then we'll go ahead and say the record is closed.
Hearings Officer Westmeyer, sorry to interrupt you. I just wanted to make a couple of staff comments, if that's okay.
Please, go ahead.
Thank you. So just two comments here. One in relation to an open record period. We were just thinking it may be good for the applicant to submit evidence into the record regarding the installation of the electrical infrastructure that he was referencing, which I think was amounting to about $38,000. And this could be the invoice and the date of installation, so we would have that in the record.
Okay.
And for that reason, an open record period may be necessary. And then secondly, I just wanted to note in relation to our initiation of use code section and substantial construction. So the applicant argued the code does not include a timing component. However, staff just notes the definition of substantial construction states when the holder of the land use approval has altered the land, and this appeared to set a timing requirement from our understanding. And that was it for staff comments.
Thank you, Mr. Johnson. Mr. Hughes, do you have a response?
I'm looking at what section he cited from. Was that from 20?
So that's the definition of substantial construction. It includes when the holder of the land use approval has altered the land.
Okay, right. I don't see that as requiring any time position. That just says the holder of the land use approval, in this case is Mr. Watson, has altered the land. So I don't think that in and of itself has any sort of time component. I think it's kind of open-ended, and it just assumes that the person who holds the approval is the one doing the changes. And I think that's what that's intended for. So that would be my response. And we do not have an objection to the, Mr. Watson has to get home to Houston, so we don't object to the record being open for a couple days, 2 to 3 days. I think that gives him plenty of time to get back he's got to go to Texas, but then he's got to get on his laptop and try to find these old receipts and give them to us. I think 2 to 3 days is plenty. I think he can do it in 2 to 3 days.
Okay, I would typically just by default do a 777-day open record period. But I'm okay with shorter if you want to do that.
3 and 3? I mean, we can shorten it down.
337.
The statute requires 7 for the final legal.
Okay, yeah, if we do the 3 and then the statutory 7.
3 and 7.
Okay. So we'll do a 3-day open record period, 3-day rebuttal period, and 7 days for the applicant final argument. What date does that put us at, Mr. Johnson?
June 2nd at 4 p.m. would be the cutoff for new evidence and testimony. And then Monday, June 5th would be the cutoff for rebuttal testimony. And then Monday, June 12th would be the cutoff for final legal argument.
June 12th, 4 p.m.
Yes.
Okay. Okay, and then I will note on the record, this is also going to toll the 150-day clock by that amount of time, 13 days. Does the applicant agree to that?
Yes, that's fine. Here.
Okay. Okay, that is noted in the record. So we'll keep the record open for that purpose to submit evidence of the testimony Mr. Watson provided today on the $38,000 in electrical upgrades with the corresponding time for rebuttal and final argument. Anything else from either party?
Not from us, Your Honor.
Okay. Hey, thank you. I apologize for the lapse in time between the two hearings, and we'll go ahead and close this hearing and safe travels.
Thank
Thank
you.
you.
Thank you.